Litigation. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We'll do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read aloud during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Andrew McNaught.
Thank you, and welcome, everybody. Thanks for spending some of your Monday morning with us. And welcome to our third and final installment of our PAGA webinar series. Final, at least for now. PAGA is ever evolving and changing, so I'm sure we will do another one of these short series soon. But even since our last installation, which focused largely on the Viking River case coming down, we've had an awful lot of developments even since then. Since we focused last time almost exclusively on Viking River, we won't do as much on that this time, although this is a sneak preview for the end, near the end of the presentation. We will do a very short follow-up, little bit sort of segment on Viking River just for a minute or two, because I think we're getting a lot of questions from clients as to how the Plaintiffs' Counsel bar has responded to Viking River. So, but most of the portion we will be spending covering other things. But before we get to the agenda, let me introduce our speakers today. My name is Andrew McNaught. I'm a partner in the San Francisco office of Seyfarth Shaw. I've been litigating class and PAGA and collective action cases for over 20 years. I practice almost exclusively in this area. And with me is Shireen Wetmore, one of my partners also here in San Francisco. Shireen has a very unique experience. She was formerly, actually started her career as an in-house lawyer at an institution of higher education. And actually she came to Seyfarth from being in-house, which is sort of the reverse of how it often works. And I know we have some Seyfarth alums sitting on this webinar right now. But Shireen has an interesting perspective, having seen and litigated wage hour, class, collective representative cases, both from an in-house position and now with us. And last but certainly not least, we have Phil Ebsworth, who's an associate in our Sacramento office, also practicing in this area. And Phil has previously been a plaintiff's lawyer, both in the UK, where he is from, and also in the United States. So he has an interesting and different perspective himself, having been on the other side of the V, litigating these cases, and he gives him a lot of strategic insight into the Plaintiffs' Counsel strategies. And Phil is also one of the few lawyers who has actually tried a PAGA case very recently. They don't go to trial all that much, so he's got a unique experience there. So that's us, and we look forward to spending the next while with you. Thank you. So our agenda today, just to go over it quickly at the top, I'm going to start by talking about manageability, which is a really key, crucial defense concept for employers to utilize in PAGA cases. And there have been some very recent rulings and developments, even just in the last few weeks, also going over earlier into this year on manageability. So we're going to cover those and also try to give you some practical pointers about how best to leverage manageability in the defense of your PAGA cases, given the current landscape. Then Phil is going to talk about splitting class and PAGA claims into separate actions or cases, which is a trend that we're seeing more and more. I was actually just emailing with a client this morning about it, but it happened in a case, but that's where plaintiffs' lawyers increasingly seem to be filing they may file a class case, they may file it in federal court, or it may get removed to federal court, but then they go and file a separate PAGA case in state court, or perhaps they're sometimes filing in 2 state court venues. But Phil is going to present some strategies and thoughts about how to best address that. And then Shireen is going to talk about strategies and best practices for addressing overlapping and follow-on PAGA claims, which are also, as I'm sure, unfortunately, some of you know, extremely common out here with plaintiffs' lawyers falling all over themselves, filing often multiple and follow-on PAGA claims against the same client, same company. And then last, we'll sort of cover briefly the Viking River update I mentioned, and sort of a potpourri of important developments, statutory, the ballot initiative, some other developments in PAGA. Given the format of this webinar, we don't have time, of course, for an in-person Q&A, but if we encourage you to put any questions you have into the chat box. We can see them. We're not going to interrupt the presentation as we go to answer them, but we will try, time allowing, to save some time at the end to address them. We probably won't get to all of them, so apologies in advance, but we will try to get to any of them we can. So that's our agenda today, and with that, I will talk about manageability and cover some of the developments that's going on with this defense and how best to leverage it. Next slide, thanks. So let's start with talking about what manageability is. In PAGA cases, it's particularly important because there is no, unlike a class action where you have this sort of natural gate checkpoint sort of, or gatekeeper function that's provided by a class certification motion, you do not have that in a PAGA case. So the plaintiffs in PAGA cases like to go straight to trial, or have a highway straight to trial. So on the defense side, we are often challenged by trying to limit the plaintiff's highway straight to trial. And often the courts. I recently appeared in a PAGA case at an initial CMC where the judge tried to set a trial date at the initial CMC on a PAGA claim with a very PAGA-only case with a very large aggrieved employee group. So sort of in the same position of trying to put the brakes on and say, well, wait a minute, even though there's no class certification motion that is going to have to be set and adjudicated, this is not, there's a lot to figure out in this case before we set it for trial. So that's really the point of what we're trying to do with manageability. And of course, the problem is with PAGA claims, given the developments generally over the last few years, in different cases, you now have a plaintiff, a former employee of yours who, a few years ago, they can allege that they suffered one predicate underlying labor code violation. Let's call it labor code violation A. But now they can allege that even though they personally suffered only labor code violation A, they can allege labor codes violations A, B, C, and D on behalf of a much wider group of people, current and former employees of yours. And by the way, even now, if they have released the underlying labor code claim on violation A in a private settlement agreement, that's no bar. They can still pursue their representative PAGA claims. And so you can see how that is problematic, as many of you know. And the real world consequence of that is that employers are subject to defending these claims, which are often subject to very expensive discovery, which happens earlier in the case often. And of course, the penalties that can accrue in PAGA actions are, or can aggregate, can be extremely significant, particularly with large groups of employees. So this concept of manageability is paramount, and what it really stems from the defendant's due process rights to litigate its individual defenses. And it really means forcing the plaintiffs, or trying to force the plaintiffs, and convincing the court to force the plaintiffs to prove, to show that the plaintiff can prove liability, not just damages, but liability on the underlying labor code claims that are alleged in the PAGA case by common evidence and in a way that comports with defendant's due process rights to litigate its individual defenses. And, you know, this concept stems from really, it goes back to the Durand versus U.S. Bank case, which was a class case, not a PAGA case, but that's the U.S. Supreme Court case in 2014 where this concept was laid out in great detail. And that's the case where the trial court allowed the plaintiffs to go to trial in a class case with this cherry-picked sample of only 19 employees, and then the court found liability and the plaintiffs got a judgment, and that was extrapolated out to a much larger group of people based on no statistical evidence or, you know, statistical propriety, shall we say. So that the Durand case talked a lot about and focused on the defendant's rights to due process rights to litigate their individual defenses, which they weren't allowed to do properly in that case. You know, manageability is also discussed in Williams versus Superior Court, which is a PAGA case. The narrow holding of Williams focuses more on the plaintiff's right to discovery in a PAGA case, and specifically to contact information of employees, purportedly aggrieved employees. But there is some helpful language in Williams, actually, to the defense side about manageability, and Williams clearly contemplates the concept of manageability and notes that, as other cases do, that it really stems from the court's inherent ability to control its own docket. You know, the court has got to be able to make sure that it's not going to be tied up for weeks and weeks and weeks and months and months and months with one case, to the detriment of all the other litigants before it. So this idea stems from the court's inherent powers to manage litigation as opposed to any procedural or statutory device. And really, the idea of manageability, it sort of stems from the predominance and superiority requirements in class cases in Rule 23B and analogs. But and critical to the issue of manageability from the defense side is that of a trial plan. I'm going to flag that phrase now. We're going to come back to it about 4 more times, but it is incredibly important because that is the vehicle by which, one of the main vehicles by which defendants want to and should be raising it to the court's attention and trying to force the plaintiffs to explain to the court, by virtue of submitting a workable trial plan, exactly how they plan to try their case in a manner, whether it's a class case or a PAGA case, how they are planning to try it in a manner that is both manageable and also comports with defendants' due process rights. Often plaintiffs will say, well, we'll just do a survey of some kind. We'll present a survey, and then we'll just use that survey at trial. We'll pick, you know, a smaller percentage. Well, the problem with that is that a survey, of course, is not evidence. It may be an offer of proof, but it doesn't provide for cross-examination by the defendants, which is the defendant's right to litigate its individual defenses. Cross-examining is part of that. And statistically, they're usually garbage as well. And so what happens with trial plans is, if you can get the plaintiffs to submit one and propose one to the court, they're often statistically garbage, and we usually have defense experts to point out exactly how that is. And the reality is, if you have a somewhat large group of PAGA purportedly aggrieved employees, let's say it's 1,000 people in a meal rest break PAGA claim, a sample that is going to be statistically valid at trial, in other words, that will allow you to try the case and with a 95% confidence interval and a 5% or so margin of error, that's going to mean bringing in probably 300 or 400 people, witnesses to trial. And that's just the aggrieved employees. You're also talking about their managers and perhaps others. And you can see how that results in very long trials. So that is the idea of manageability, and that is why it's important to force plaintiffs early and often to start articulating how, in fact, they're going to do this. So there have been some very recent developments, and if you could go to the next slide, I'm going to focus on those for a minute. So last fall, a very important case came down from the Court of Appeal in California called Wesson versus Staples. Prior to last fall, there had been a lot of arguments about manageability with the plaintiff's bar. As the plaintiff's bar would often point out, and still does, there's no manageability requirement written into the PAGA statute. There's no word that says manageability in the statute. However, we certainly, on the defense side, were trying to leverage manageability. And it was very much a mixed bag. There were many state courts that were very reluctant to dismiss or even limit sometimes the scope of PAGA claims based on manageability concerns. Some would. It would be very judge-specific, but many wouldn't. And the same construct was true in federal courts. There are a number of federal court decisions where federal courts do strike PAGA claims based on manageabilities and others that do not. So it was sort of this very mixed landscape. And then this Wesson case came out in September of last year, and it was a very important case. It involved store managers, about 345 exempt store managers for Staples, and obviously it was an exemption case, and it was also a class PAGA hybrid case, and the court denied the plaintiff's class certification motion, and then after that also struck its PAGA claim for lack of manageability. And it was really the first time a court of appeal had unequivocally held that courts have an inherent authority to ensure that PAGA claims can be fairly and efficiently tried, and if necessary, trial courts may strike claims that cannot be rendered manageable at trial. And you can see the quote on the slide. This language is very important. As a matter of due process, the court recognized defendants are entitled to fair opportunity to litigate their affirmative defenses, and that therefore the court should ensure that both the claims and defenses can be manageably tried. And that's really key language, specifically the word defenses, because, of course, the plaintiffs are always focused on answering the question to the extent they'll answer it at all, how their claims, their offensive claims may be manageably tried, and they like to skip over the equally important concern that the Wesson court highlights here, which is that how the defendant's defenses may be manageably tried in a way that comports with defendant's due process rights is extremely important, just as important. So that was a huge, case. It was a welcome lifeline to employers. It provided some specificity in a world that was very sort of scattered, both in state and federal court on this point. I will say the Wesson case was, it was quite nuanced. It didn't go overboard. It recognized that striking a PAGA claim based on unmanageability is sort of a last resort, and it's not going to happen in every case, and courts should be careful about it. But that it was, at the end of the day, sort of an arrow that a trial court has in its quiver if it really needs to use it. There were some specific facts in the Wesson case that led to the result there, one of which was that the plaintiff's counsel did not dispute the defendant's assertion that an individual trial for each of these 345 store managers would take about 6 days per store manager for the defendant to litigate its individual defenses with respect to the exemption status of each store manager, and that would take 6 days, and when you added all that up, it would mean a trial of about 8 years, not months. And the defendant argued that, and for some reason the plaintiff didn't dispute it. So you had that fact where the trial court was faced with an 8-year trial, which is just clearly unmanageable. And also, the other main fact that led to the result was that the plaintiffs in that case essentially refused to produce a trial plan. The court asked them for one, the defendant properly teed it up, and on numerous occasions, the court asked the plaintiffs to explain to the court how they were going to manageably try this case in a way that wouldn't take 8 years, and the plaintiffs just kept saying, there's no need for a trial plan, there's no manageability requirement, we don't have to do a trial plan, we'll do it based on common evidence, we'll figure it out, we'll show you later, and the court was not having that. So that's not going to happen in every case, but those facts, I think, did turn the Wesson case into the result that it was. Okay, next slide, please. So since Wesson last fall, there's been a lot of developments this spring on manageability, the most important of which is on March 23rd, this other 4th District, Wesson was in the 2nd District Court of Appeal, the 4th District Court of Appeal issued this decision in Estrada versus Royalty Carpet Mills. This is a meal and rest break PAGA case, class PAGA hybrid, and there the court, the judge in Orange County, after a trial actually and some certification, he ended up decertifying the meal and rest break class, and then went ahead and granted the defendant's motion to, motion to strike the PAGA claim. That's what the trial court did. It went up on appeal, and Estrada basically, said, look, we recognize Wesson is the only published authority in the Court of Appeal that addresses manageability, but it's wrong. We disagree with it. We agree more with some of the federal courts who had refused to recognize manageability, and it went through this analysis. Essentially, the analysis is always the same, which is that PAGA is different than a class action. It's a regulatory enforcement action where the plaintiff is standing in the shoes of the state of California, and therefore it's not trying to graft a manageability requirement onto a PAGA case is not fair, because the LWDA, when it investigates cases and claims, isn't beholden to any manageability requirement. Of course, the LWDA hardly ever actually does investigate cases and claims, which is why this area is driven entirely by plaintiff's lawyers. But anyways, it created a, really probably the most significant split in authority on a PAGA issue in PAGA's 18-year history as a statute. So you have these two different courts of appeal, districts of the Court of Appeal in California saying opposite things on manageability. A lot of what the Estrada case said doesn't really make sense. It laid down an absolute rule, and that's why I refer to it as a sledgehammer in the bullet down there, and it's not particularly thoughtful and nuanced in the way that Wesson was. It just says striking a PAGA claim based on manageability is not something a trial court can do, period. However, it then recognized many of the concerns expressed by Wesson, and then went on to sort of say a lot of things that make no sense, like, well, if the plaintiff can't really show the court how the case could be manageably and efficiently tried at trial, maybe they'll just recover fewer penalties. It'll just be a smaller recovery. I mean, you can read the case. I won't get into it now in the weeds, but it doesn't make a lot of sense, frankly. But that's out there. And so the question is what to do now. Well, Wesson and Estrada are both good law right now. However, on June 22nd of this year, the California Supreme Court just granted review in Estrada. As people expected, it will resolve this split. And then right after that, 8 days later, we got a Ninth Circuit decision in Hamilton versus Walmart, which essentially echoed the Estrada decision that trial courts lack the inherent authority to dismiss PAGA claims based on manageability. I think the import probably of the federal court Ninth Circuit case is going to be more limited, and because PAGA claims are less often in federal court for other reasons also, but you know, there are federal court cases that have been helpful, Phelps versus Cox Communication being one of them, that have dismissed PAGA cases based on manageability. So cases like that are going to be, you know, overruled for the time being. I think ultimately what this California Supreme Court does in resolving the Estrada-Wesson split will probably guide the Ninth Circuit going forward in terms of what it's going to do on this issue. So the question is, what's going to happen? We don't know. I mean, the California Supreme Court is going to take a year or two to address this split, and both cases can be cited and should be cited. Well, Wesson should be cited in that intervening time, so maybe that's a reason to tee up your manageability arguments under Wesson now, before the Supreme Court rules. You know, there's a lot of understandable cynicism, some of it coming from myself, about what the California Supreme Court will do, since it's not employer friendly, and I think a lot of people think it's just going to, you know, get rid of Wesson and wholly endorse Estrada. We'll see. I mean, it might, but, you know, if it really reads Duran and Williams, as I said earlier, and tries to harmonize those things and the concepts in those cases, it may do something a little bit more nuanced and try to strike some balance between Estrada and Wesson that maybe employers can live with a little better. We'll see. But in the meanwhile, Wesson is good law, and we should use it. So how do we use it is the question, and that's on the next slide. So the key point, and this will be the last slide in manageability, the key point is all is not lost, and Wesson is still good law, and manageability is still absolutely critical in your PAGA cases. So think carefully about when and how and to what ends to leverage those arguments. Talk with your counsel about it, but it's really important. You can do it at the demur, you know, responsive pleading stage. You know, it's very unlikely that courts will usually dismiss outright a PAGA claim based on manageability at that early stage in the case, but I've done it at that stage in the case in conjunction with other arguments that I had on demur, but really just for the purpose of alerting the court to the issue and flagging it very early, even though I didn't expect to win on it. I did that in a case recently. Raise it at case management conferences. You know, many of the larger courts that have complex litigation departments where we're litigating these cases, you know, they have very sort of informal federal court style case management conferences where there's a lot of discussion. You know, raise the trial plan issue at those conferences, at the very first case management conference. You want to plant the seed in the judge's mind about this issue and forcing the plaintiff to explain sooner rather than later how they're going to manageably try a PAGA case. And if they can't, they should be dismissed. There's still a great deal of opportunity to use manageability in the discovery context at different points in the case, filing motions to sequence discovery, sometimes even bifurcating trial. You can highlight manageability arguments in filing discovery motions in which you're seeking to limit the scope of discovery to perhaps a smaller group of purportedly aggrieved employees or a specific number of facilities. That's an effective tool often in cabining the completely ridiculous and overbroad discovery requests that come with PAGA cases at the outset. And of course, you can still file a motion to dismiss or strike. It is still valid under Wesson. You need to think about when the best time to file that is. Usually it tends to be a little bit later on in the case. I think most courts are probably wanting to have at least some discovery done and some discovery and evidence in the record to see a motion like that, to have it be based on rather than very early in the case before essentially any discovery has been done. But all of those are important to think about. This still remains an important tool, and the trial plan issue is paramount in the manageability analysis you should be doing. So just say trial plan to yourself. I won't make you say it with me. All right, well, I'm going to wrap up this segment, and I think Phil is going to take us into the next segment about splitting class and PAGA claims.
Yeah, so moving from defense strategy to a little bit more of a focus on plaintiff strategy. So over the last year or so, there's been a growing trend among the plaintiffs' bar to separate out the class and PAGA claims into two separate lawsuits. That can often mean you end up with two lawsuits filed in the same court with the same parties, same attorneys, and same claims, but you are dealing with two separate lawsuits still. So that gives obviously the employers twice as many lawsuits to defend, and also the employee with a second bite of the apple, essentially at critical stages of litigation. And so with the possibility of having two cases which end up on different timelines and different rulings on the same issues, this can be a real headache for employers. So why do plaintiffs do this? It might sound a bit obvious, but there's a couple of key strategy reasons as well, if we go to the next slide. The first one is it avoids federal court. PAGA claims are very hard to remove to federal court when they're filed by themselves and not attached to a class claim. So for actions against non-California employers, it's an attempt to really litigate these wage and hour claims, which, like I said, are the same in both the class and the PAGA case in federal court, in state court, sorry, and not in federal court. The class claims often can be removed to federal court relatively easily, assuming the size of the class is big enough. But with the difficulty in removing a PAGA-only case, this is kind of a real driving point for a lot of plaintiffs' attorneys. And it's a saying as old as time that we always say that federal court is better for defendants than state court, but it is particularly true in these PAGA cases. For example, a lot of wage and hour complaints fail to meet federal pleading standards, and that gives a real opportunity to narrow the scope of litigation at the start. And obviously, if you're not in federal court on your PAGA case, then you're stuck with the much lower standard that California courts and judges hold plaintiffs to. Similarly, in state court, you have very little or close to no restrictions on the scope and quantity of discovery, and so again, you're fighting a much broader battlefield than you would be if you're able to narrow that scope, maybe with a 12b6 motion in federal court. And most importantly, for the plaintiffs' bar, you're way more likely to get a higher percentage of attorney's fees if you're in state court than you're in federal court. And so that's kind of often the primary drive in separating out these claims into two lawsuits. Another reason is to avoid coordination. So when there are multiple or overlapping class and PAGA claims in state courts, it can be in some situations for employers to coordinate these actions with the state's judicial council. So this collects all the wage hour litigation in the state and puts it in one court in front of one judge. Think multi-district litigation, but just for the state of California. Plaintiffs often don't like this because they have to essentially fight with each other to be the lead counsel and then also work together, which at least I think in my experience, and I think Andrew and Shireen would agree with me, is not something that they're used to or maybe even particularly good at. So often they resist coordination as much as possible. Unfortunately, one of the requirements to include a case in these kind of coordinated proceedings with the Judicial Council is the case has to have been deemed complex by the trial court. Now, class actions are automatically qualify as a complex case. However, in some counties and some state courts, they don't consider PAGA cases as complex. And so without that designation, the PAGA-only case couldn't be coordinated and would remain out there to be litigated independently. So it's so by filing a PAGA case separately, the plaintiffs are removing that possibility for defendants to try and coordinate all the litigation into one coordinated proceeding. Another reason is more discovery. With class actions, there's the arguments that we can make to limit discovery to pre-certification discovery before getting into the real weeds of the claims. And also we can limit discovery somewhat to claims which the plaintiff has personally experienced. Again, with PAGA, those kind of limitations are either non-existent or very hard to get a judge to enforce. And lastly, it increases the cost to employers and also the value to plaintiffs. Like I said at the start, with two cases, you have twice as much work. And while there is some overlap in the defense because you're looking at the same facts and the same claims, you're still dealing with double the pleadings, double the discovery, double the motions, and at the end of the day, if we get to it, double the trials. And so it's a real kind of weapon for the plaintiffs to use to really put the screws to employers. And on the other side of things, because the value of PAGA claims are heavily discounted for a number of reasons when considered in conjunction with class claims, we've seen by splitting the class and the PAGA claims out, that plaintiffs can attempt to really leverage an increase in value of an overall settlement for class and PAGA claims by splitting them into two different actions. So those are some of the reasons why we see it. But what are the things that we can do in response? So I think, first of all, if we go to the next slide, it's not always a given that a PAGA case can't be removed. I mean, more often than not, it is the case, but there are opportunities to remove them. For example, if you are dealing with a unionized workforce or a part of the group of employees that the plaintiff is attempting to represent, there's a collective bargaining agreement involved in even a subgroup of those. There are opportunities to remove the PAGA case under LMRA preemption. So don't automatically think just because they've filed a PAGA case separately that has to stay in state court. That's not necessarily the case. Secondly, and something that we see more often, and we've had some success with recently, is convincing the state court judges that are left with the PAGA-only action to stay the PAGA case pending resolution of the class action. This can be a real course-setting win at the outset of litigation. Not only does it knock out all the advantages for the plaintiffs of splitting the cases up, but now the plaintiffs have to litigate the class claims without the advantages which come with a PAGA claim, so like broader discovery rights, things like that. And so that can really set the course. It's not only is it just an early motion win for the employer, but it can really set the course and the breadth of the litigation moving forward. Another thing that's important to do is whenever a PAGA-only case is filed is to check how plaintiff's counsel has designated the case, whether it's complex or non-complex, and if the court has already made a determination on that. And then if it's in line with an overall litigation strategy, looking at the case and any other class or PAGA cases that are being dealt with, be sure to counter-designate. The defendant, the employer, has a right to counter-designate as complex if needed, and take the steps to have that designation heard. In some court, that differs from court to court. Sometimes it even requires a noticed and briefed hearing. But if that's something that is going to fit in with the overall litigation strategy, be sure to exercise that ability to counter designate the case as complex and take the steps that need to have that a hearing on that designation. Again, something that can be course setting and really guide the direction of where litigation is going to go. And last but not least, speak to plaintiff's counsel. We always make jokes and complaints about maybe plaintiff's counsel being a bit unreasonable, but I've had success in the past of reaching out to plaintiff's counsel and asking them to, combine the class and PAGA cases together into one action, even if they filed them separately. For example, I've seen for some counsel that the main reason they've done it is to avoid removal, and if in fact the defendant doesn't have grounds for removal, if they're a California entity, or even if the deadline to remove has passed, plaintiffs' counsel have not had any issue with combining those two actions into one action, and so we can proceed just with one case in front of one judge, and that removes a lot of the headache of having these two separate actions. So as you can appreciate, the response to plaintiffs' recent tactic of splitting class and PAGA claims can be very situation specific, and it needs to take into consideration not only the claims and the defenses that we intend to litigate, but also the broader litigation landscape that the employer is facing or may expect to face in the near future. So, and the response at the early outset of litigation is one that can really set the direction for litigation moving forward. And so considering all possible opportunities and determining what the best response would be can be really critical to our success of defending these cases moving forward. And now I'm going to hand over to Shireen to talk about some other trends that we've been seeing.
Thanks, Phil. Yeah, so as Phil said, we're now going to talk briefly about two types of trends that we're seeing, which manifests in a variety of ways: overlapping and follow-on PAGA claims. So a little different from what Phil was talking about here. These are multiple complaints, all based on just a PAGA claim. But before we begin, we wanted to do a brief pause for context, a theme that we see over and over again. How do we get here? Well, as we all know by now, the practical reality of PAGA is that these cases are driven in large part by attorney's fees. And while this is not unique to PAGA, what is unique and what may be driving some of the trends we're seeing is that PAGA provides unique opportunities for multiple counsel to obtain fees essentially on behalf of the same claimant, the labor commissioner, for the exact same claims. And so some of these procedural mechanisms enable plaintiffs to extract additional fees for comparatively little work. And so how that manifests are several different trends that we're seeing, but we're going to talk about these two. So what does it look like in practice? Let's start with the overlapping claims. So next slide, please. And these are claims where different plaintiffs and separate counsel are bringing claims covering the same time period and the same defendants or similar or nearly identical claims. And so how this comes about, to start, is there are really no limits to how many LWDA notices that can be filed against a given employer. And it can be by multiple complainants all at the same time. And one, for example, might add a slightly different claim or a new labor code provision, or simply just describe different facts to support the same claims. So a business expenses claim, the facts in one letter might say, my cell phone wasn't paid for. The facts in the next one say, I had to get my own coffee in the morning. Who knows what they're going to claim, but then they're going to bring their own separate letter. Or they may have a different definition of the aggrieved employee population. So maybe all non-exempt employees, maybe different subsets of that hourly population, maybe all of California or a couple different facilities. So then the question is, why? Why would you bring an overlapping claim? And it could be that plaintiff is seeking to extract their own enhancement award or separate attorney's fees. Always in the back of our minds, I think, as defense counsel, and I'm sure in the back of your minds as employers. Or it could be that plaintiff truly believes there are deficiencies in the original claim, and there are arguments to be made that haven't been brought to the fore, or they may have no idea that there are other complainants already out there with these letters and notices submitted to the same employer. So what can we do with these overlapping claims? Well, one option is to stay the top filers. And there's a recent case, Shaw versus the Superior Court of Contra Costa County, BevMo case, that came out on May 3rd of this year. And in that, the California Court of Appeal for the First Appellate District confirmed that the rule of exclusive concurrent jurisdiction applies in the context of PAGA to stay a later filed duplicative PAGA case or cases. And this judge-made doctrine holds that when two or more courts have subject matter jurisdiction over a dispute, the court that first asserts jurisdiction assumes it to the exclusion of all others. So in other words, oversimplifying a little bit, but the first to file gets to litigate while everyone else has to wait. And although the court in Shaw declined to clarify whether the rule of exclusive concurrent jurisdiction is mandatory, which would be awesome, or discretionary, the court held that either way, PAGA does not abrogate the rule, and if it's discretionary, the standard of review is abuse of discretion. The court in Shaw found that that there was no abuse of discretion in the lower court's ruling that was applying this rule of exclusive concurrent jurisdiction to stay a latter filed and essentially wholly duplicative PAGA claim. So that remains an option. Seek to stay the claims of all these top filers while litigating the original claim. But the other option is to leverage the competition between all of these counsel and their plaintiffs to settle claims at the best rate. And there are some important considerations to include when you're thinking of leveraging, and again, Phil is our star for having taken a PAGA case all the way to trial, but as we all know out here, that is few and far between, and the vast majority of the time, these PAGA claims end up being settled. And so you want to consider whether and how to encompass the labor code provisions that have been cited by each of the plaintiffs, either by covering a longer period than the statute of limitations would permit, so reaching back to the earliest possible date under all of these overlapping claims, or to cover additional labor code provisions, which you may be doing through an amended PAGA notice or otherwise. We'll talk a little later about some of these recent developments in intervener or attempts by other plaintiffs to intervene in cases, which may complicate that a little bit. But one quick word of caution here as well from the recent decision in Grande versus Eisenhower Medical Center, which was decided on June 30th by the California Supreme Court. It's important to name the parties you wish to release in the negotiated release. That case involved a different type of overlapping claim than what we've been talking about so far. The original matter named a different defendant, the staffing company, while the later filed overlapping claim named the hospital where the plaintiff had been placed by the staffing company. And the moral of that story was that claim preclusion only applies to named parties in an action or release, or someone with in privity with a party in the first action. So there, the plaintiff was the same, as were the allegations and claims, but the defendants were different. So you can see that there are a lot of different ways that claims or aspects of claims could overlap. And in many cases, PAGA overlapping claims may form a bit of like a Venn diagram, with some of the overlapping claims being the substantive claims, some may be portions of the aggrieved employee population, the employer defendants may overlap in some ways, or the time periods that are covered. So that brings me to the second trend that we're seeing in these multiple PAGA actions, and that is serial or follow-on claims. And this is where multiple plaintiffs and separate counsel bring serial claims covering the same defendants and similar or nearly identical claims, just as before, but with a PAGA period starting after the end of the prior matter's settlement release period. So again, predominantly focused on situations where their cases are settling and not going to trial. If they're going to trial, Bill's going to win that one for you. So. But so how does this work, right? Serial PAGA letters. Claimants, as we said before, they can submit letters to the LWDA without regard to previous claims, previous settlements. There's no limit to the number of LWDA letters that they can file. And there's, as Andrew mentioned earlier, there's very few instances where the labor commissioner is going to intervene or get involved in these cases, take them up on their own. So it costs almost nothing to the plaintiff's counsel to take somebody on, write a letter, see where it goes. And then the serial complaints themselves, they may be filed in different courts. They may be top files, like the overlapping claims we just talked about. Or they may file the letter, and then plaintiff's counsel and plaintiff may choose to wait for a settlement or a notice to the court of settlement in another matter, and then agree to stay their case, look for the resolution of that originally filed case, and then go ahead and move forward with their case. And why might they want to do this? Well, they may want to join the earlier filed case that hasn't settled yet and try to extract a portion of the fees while settlement's being finalized, essentially to insert themselves or to intervene. I have seen this where plaintiff's counsel end up working it out amongst themselves if it's far enough along in the settlement process. But there is now a narrowing split of authority on whether and when claimants can intervene or object to PAGA settlements, with the recent balance sort of shifting in the employee's favor. So we expect to see more of those efforts in the future. Another reason may be that the claimant prefers to wait this short period of time and obtain easy fees with little work, as the employer has already looked at all the issues but may not have implemented their solutions. And as we know with PAGA penalties, they stack up very quickly. So a plaintiff and their counsel may decide that even a short couple month period is lucrative enough to go ahead and proceed with their follow-on or serial claim. And we know, I think Andrew mentioned at the outset, we are seeing employers with what feels like just a constant churn of these back-to-back PAGA follow-on claims, which can be very, very frustrating. So what can we do to fight back about it? Well, we recommend a lessons learned debrief and then taking some action. So following any PAGA matter, you want to speak with your counsel about ways to improve company practices to avoid future suits. So even where there was no liability found, ask how you can improve the company policies and procedures to better document the compliance, what actions you can take to minimize interruptions during a meal period, for example, or other solutions that may deter plaintiff's counsel, make the case feel a little more complicated for them. And then, of course, you want to make sure that you're actually implementing all of these changes and that you're obtaining buy-in from your key stakeholders. And we recommend doing that early on. So even as you're working on your maybe first or second PAGA action, really talking to the teams that are impacted by this in order to make sure that, once you identify changes that can be made to help prevent future cases, that you're already taking steps or ready to launch those steps as soon as the matter settles. And then, of course, in light of Viking River, much talked about, you may want to consider an arbitration agreement for your employees as well. So, and then, of course, don't want to forget, if you want to argue claim preclusion, you want to make sure that the release in the earlier settled matter names all of the relevant parties, particularly important when, as a defendant, you are a company with multiple layers of business entities that may be impacted, or you have some sort of potential joint employer relationship with other potential defendants, named or unnamed, in one or more of these serial claims. And then next slide, please. So finally, with all of these overlapping and serial claims, many a client have asked us, is there a plaintiff's bar conspiracy here? We think likely no, but there are some attorneys that may be trolling, probably not the nicest word, but the LWDA online repository to see which companies have pending PAGA letters and then seeking out potential plaintiffs. That repository is available online. It's free. It's fairly easy to search, and it's available to the public. So that's one possibility. But often we find that the later filed counsel has no idea that they are or have been top filed. And so they're just, a little late to the party, or second or third to the trough, as I borrow that phrase from Andrew here. Um, and so, frequently we've seen when they learn about the competing claims, plaintiffs may decide to forego their claims altogether, or at least stay their matters pending the resolution of the earlier filed matter. But as more plaintiffs seek to test the boundaries of cases permitting interveners, we anticipate that there's going to be more pushback from top filers and potentially an increase in demands to participate in the broader resolution of these matters. Um, so, you know, a future trend to anticipate. And with that, I think I want to kick it back to Andrew to discuss some key recent developments, and some tea leaf reading as well. So Andrew, take it away.
Thanks, Shireen. Let me read the CLE code first. The CLE code is SS 4341, SS like Seyfarth Shaw, SS 4341. And next slide, thank you. I'm going to talk very briefly about key recent PAGA development. We're running out of time, and I apologize we're not going to be able to get to any of these questions. Appreciate they're being submitted, but obviously follow up with your friendly Seyfarth attorney with specific questions if appropriate. But real quick, just in the next few minutes, I wanted to run through the issues on this slide. So there's been a lot of clients, as I mentioned at the top, asking about what we're seeing the plaintiffs bar do in response to Viking River. And I would say that it's been sort of a mixed bag. There are some plaintiffs lawyers, I would say the better plaintiffs lawyers, are agreeing to settle PAGA cases individually. They're not going to challenge the arbitration, agreement. Obviously, this is applicable to PAGA cases where there's an arbitration agreement, but I would say that those are in the minority, and there are more plaintiffs lawyers, and probably the less savory ones. I'm trying to be politic about how I say things, but they are what a lot of us are seeing is that they are basically trying to buy time. I think a lot of plaintiffs lawyers believe, based on Justice Sotomayor's concurrence in that case, that her invitation essentially for the California Court of Appeal or our legislature to fix PAGA, in of course in a way that benefits employees and plaintiffs. So a lot of what we're seeing is plaintiffs lawyers inviting us, forcing defendants, our clients, to file motions to compel on perfectly valid arbitration agreements with PAGA waivers, which they know they're going to lose, but they want to do that so then they can bring the issue up to appeal, and they just want to keep the case alive in the hopes that sooner rather than later the Court of Appeal or the legislature is going to intervene. So that's that. Just a couple other key cases that have come down recently worth mentioning. LaFace versus Ralph's Grocery came down in February this year. It confirmed that there's no constitutional right to a jury trial in a PAGA case, among other things, but that had been sort of assumed, and we always argued it, but it hadn't been entirely clear prior to LaFace, so that's just an important case to look at. And then very recently, I think just last week, this Business and Industrial Alliance versus Becerra came down, which held that PAGA is constitutional. Various industry groups and defendants have been pushing this argument for quite a few years now that it violates the separation of powers and it's unconstitutional. I think the California Supreme Court has finally put a stake in that notion. And then there was an important statutory exemption that came in the first of this year. it's very narrow, but it's important to certain of you who may have janitors. In California, it's a labor code 2699.8. It's an industry exemption for PAGA, and it's the second one. There was one on behalf of the construction industry that came in 2019. But basically, it says if these janitors or these construction workers in the prior one are subject to a collective bargaining agreement that meet certain standards, the most important of which being that they have to be paid at least 30% over the minimum wage, and they have to be doing very specific things and working in specific facilities that really make them janitors or construction workers. But if they meet all these requirements, then they are exempt and they may not pursue PAGA claims. So again, narrow industry-focused exemptions, but important if you have employees, obviously, in those industries in California. And lastly, I just wanted to mention this ballot initiative. I know there's been a lot of interest in that. This came up last fall. It was started, the Fair Pay Employer Accountability Act. They were trying to qualify it for the November ballot this year. They have, as of just May this year, they have decided not to do that. They've given up. Apparently, they collected something like 640,000 odd signatures, but there was some timing issue about allowing the elections department to verify all the signatures. And it's sort of unclear why they pulled back, this industry group, but they have pulled it back for now. So it is not going to be on the November ballot. However, these industry groups, and this is supported by the Chamber of Commerce, have said that they do intend to attempt to requalify for the general election ballot in November of 24. So it's the idea is not dead, but it's on pause. And I'll leave it there. We could have a long discussion about whether that is ever going to pass in California. But we're past time by a couple minutes, so I'll wrap it up there. Read the CLE code one more time for those who didn't get it. SS, Seyfarth Shaw, SS 4341. And really want to thank all of you for taking some time out of your busy Monday mornings to join us on PAGA. Thanks, everybody.